Okay, well, good morning or good afternoon to everybody. Thanks for standing by for the moment there as we got the slides all queued up. So welcome to Patexia's IP Matters webinar series. We're officially back in full swing. It's been a while since we've. This particular installment is the ins and outs of crowdsourcing. I'm your presenter today. My name is Kyle Holger. I'm Patexia's Director of Client Solutions, and I'll be walking you through some general best practices in crowdsourcing and what we've learned from our experience being in the business of crowdsourcing in property for the past few years. So today I'm going to talk to you about, first of all, the history of crowdsourcing. We're going to go through some crowdsourcing IP challenges. Then we'll get into some specific crowdsourcing applications, some case studies, if you will. Second to last, I should say, we'll talk about prior art, estoppel, and the PTAB in light of the recent PTAB decision. And lastly, future crowdsourcing initiatives that we're excited about being a part of. So to begin with the history of crowdsourcing, and I guess before we jump right into that, I want to remind everybody that if you're watching, you can tweet your questions to us at a hashtag IP Matters. So now getting into the history of crowdsourcing, well before there was a buzzword associated with what we're doing here, which was actually coined by Jeff Howe in 2006. The idea of using the wisdom of the crowd is it's been around for quite some, starting in as early as 1714, one of the earliest known examples of crowdsourcing. The British government was offering something in the range of about, I think, £20,000 to solve what was called the longitude problem. It was a navigation issue that was killing quite a few sailors, and they wanted to have this problem solved as soon as possible. So what came out of that was the invention of the marine pocket clock, and somebody walked away with quite a good bit of money, which £20,000 is even still pretty solid, and that was pretty solid back then in 1714. Jumping ahead now to the 1900s, we saw crowdsourcing take root in some design contests, things you're probably very familiar with even today. So Toyota hosted a logo design contest in 1936. The Sydney Opera House had a contest in 1955. That's two really major examples that are still standing here today. And then jumping ahead into the 2000s, we really saw an explosion of crowdsourcing, really predicated by the interconnectedness afforded by the internet. So really one of the first seminal examples of this was Wikipedia in 2001. We saw American Idol start in 2002, which was a crowdsourcing competition for talent, or depending on how you look at it, for content at the very least. It is obviously a very important example of this as well, again, crowdsourcing content. And then last but not least, we have Patexia in 2010. And again, we're a crowdsourcing platform that works in the intellectual property space. All right, so now moving on, we're going to talk about some crowdsourcing solutions to in-launches. So I guess to start out by defining what we see as really the core or the fundamental problem facing the world of intellectual property is consistent and efficient quality technical information. So all the examples I just gave before were in essence aimed at gathering some type of information, whether that be songs or whether that be solutions to that navigation problem that I mentioned. So Patexia is tasked with solving a problem here in the intellectual property in terms of getting high quality technical information to the right people. And this problem, it results in a number of different symptoms that we're currently seeing in terms of increased patent litigation. It's still at about a high all-time patent litigation in this country. We're seeing historic backlogs at the USPTO in terms of time from application to examination, and we're seeing things like the challenge success rate in front of the PTAB. Number of claims are being struck down, and again, this is ultimately what we think rooted in the fundamental problem of intellectual property, really the challenge of when issuing intellectual property assets. So here at Patexia, we see crowdsourcing as a solution to problems like this. And in general, as really a best practice, effective crowdsourcing comes about when you have large, diverse, and relevant networks with access to a variety of different resources in multiple languages. And with that comes multiple perspectives, a unique look at a problem, which you can't really get when just working with small groups. So in our, in our business here, again, working in intellectual property and then using our own experience to color this a little bit, in terms of a large and diverse network, we see people that range from professional intellectual property searchers to professors, or maybe even graduate students or postdocs, industry professionals, patent attorneys, or patent examiners, and gathering the different perspectives and opinions that people can have about problems has a powerful tool. Again, access to resources in our circumstances means things like, publicly available databases, the USPTO or the EPO, but then also proprietary tools such as IEEE and multiple languages and perspective itself. So we like to look at the building a bridge concept as really fundamentally crucial to an effective crowdsourcing tool, because a lot of times problems result from miscommunication. I think this is true in life, in all aspects of life, whether it's professional or even personal. So we often come from, again, in our experience here, IP intensive organizations. These could be major tech companies, or sometimes the attorneys representing those tech companies. But this could also be major research universities commercializing some intellectual property, as well as government organizations. And then the solvers are generally going to come from academia, from universities, again, as either graduate students, postdocs, or professors. Certainly there's plenty of industry professionals with a lot of useful insight as research is done early days at the university level. And really, we see that there's a difference, again, in terms of communication, but it comes down to what we see as the form of currency. In the world of intellectual property, currency is patents, which are crafted and designed to be a certain way. And on the other side, we see the currency being papers and publications, which are really meant to be very clear, really collaborative, so that others can basically stand upon the shoulders of researchers that came before them. So a little bit of a discrepancy there, which has resulted, again, in that fundamental problem we've talked about of accessing technical information. So in terms of being a bridge, Patexia likes to think of itself in the middle of these two sides of the problem. And to do so and to be an effective bridge, we like to simplify the problem, technical language, which is the appropriate language we feel in this situation, and really provide the right communication channels. It's essential to have an appropriate interface where it's easy and even fun to do something like this. We've tried to gamify this type of research a bit, and that's really important for bringing people together with a vested interest in. Now, in terms of the process, again, this is a pretty general process that applies to a number of different crowdsourcing companies, and we certainly do use it here as we've applied it to our intellectual property due diligence tool. So again, generally, going back to this building a bridge concept, designing a challenge is critically important to a successful crowdsourcing outcome. Once you challenge or the task at hand out there, it really stands on its own, and it needs to be able to weather the storm and really be as clear as possible so that we're getting the right types of answers, what we're looking for. So in terms of designing a challenge here, our research team is actually responsible for crafting some technical questions and then presenting that to our crowd of experts, essentially crowdsourcing these questions now to this global community of experts. And another important facet of this is also the moderation and the review of these responses can be sometimes a bit noisy, to even messy in certain circumstances, and you need to be able to really make sense of the data. You're going to get a lot of different responses, a lot of them really useful, others not so much, and so having a team that can kind of moderate and review what's received and ultimately condense that into a meaningful report, something that a client or an interested party can make a meaningful decision from is really important. And then below that, we see a bit of a schematic. So in this situation, the A over here using its own interface A, for example, companies then allowed to ask questions, basically posting them to this interface. The crowd or the community is going to submit its answers, and then the interface and the company will be responsible for filtering those answers again into some meaningful data that will have some direct business use. So now let's take a little bit of a step forward and we'll go into some sample crowdsourcing applications. So first off, going back to, I guess what I've described so far as that fundamental challenge facing intellectual property is Due diligence being, and I think this is especially true when it comes to intellectual property as an asset. When you contrast that with something that's a lot more tangible, something like real estate, it's often very tricky to put a really meaningful dollar amount on an intellectual asset. So we break the problem down into three core components: validity, infringement, and market size. So these are all crowdsourcing applications that we've undertaken ourselves. And I can kind of walk you through what each of those looks like in a little bit more detail as we go forward. So first of all, we have crowdsourcing for IP protection. So to clarify what that means a little bit, we have some use cases that include patentability, patent validity, and freedom to operate. This is essentially ensuring that what you have is going to be legitimately protect the status it's been granted in terms of intellectual property. So when it comes to, I guess, a high-level look at what the process is like, again, our team or, a crowdsourcing company could design some technical questions from patent claims or perhaps the disclosures if it's yet to be granted by the USPTO. We look for relevant art, gather those responses, and ultimately build claim charts to determine the patent's validity or the viability of the idea. On the other side of that coin, as a lot of people look at it, we have crowdsourcing for IP monetization. So a couple of use cases here include evidence of use, basically a crowdsourced infringement analysis, and what we like to call lead generation. So essentially going out there and finding some opportunities off diversity context where we can find some licensees, some leads that you can go out there and essentially talk to about licensing your technology or getting involved in a potential spin-out of a startup company from the university. So again, the previous example for crowdsourcing of IP protection, we can design some technical questions from, in this case, they're oftentimes a bit broader. We like to cast a very wide net because, as anybody would tell you, having more examples or maybe more claim charts at the negotiation table is generally going to be a stronger result. And in this example, it's a potential infringement. Again, gathering those, some claim charts to support patent licensing or other monetization. And the third pillar of what we've talked about in terms of contributing to proper IP valuation is really sourcing IP analysis. And the main use case here is going to be market research. So in this situation, once again, we'll be designing some questions, but in this circumstance, they're oftentimes non-technical. We'll be asking some questions about the market, whether it's top players, some things, unit shipped, revenue, things like that. There's generally going to be some kind of technical or intellectual property slant to it, but that's not always the case. This can actually be quite a bit broader in terms of the overall use case. Questions, and now we're crowdsourcing opinions, gathering responses, and really trying to build some meaningful consensus from the data. And that's the point I wanted to spend a little bit more time on, because with crowdsourcing, one of the really powerful aspects is that by getting so many different responses, you can make some saying in terms of positives and negatives. So if a lot of different people are all saying the same thing, you have maybe a higher degree of confidence that what they're saying is in fact true. Where on the other side of things, of course, you cannot prove a negative, but by having so many responses, again, you feel a higher degree of confidence that you can move forward data to do that. So now we're going to kind of touch upon what I described before as prior art, estoppel, and the PTAB. In light of a recent PTAB to send us back into why access to relevant technical information is critically important, and I think it will be more so even going forward. So, if some of you are familiar, it was December 10th, 2014, which denied hearing of a petitioner's request or for a rehearing, of non-institution of an IPR petition. So this was basically Unilever versus Procter and Gamble. And what the PTAB decided was that the second petition was not going to be, or even the rehearing was not going to be heard, because the second would be raising substantially the same prior art or argument as the first petition. This resulted in the petitioner being stopped from using any new prior art in a second petition or available at the time of first petition. And that's kind of the really important part here. Is it's one thing to have been aware of some prior art and then chosen not to share that in a petition or with the PTAB, but even if you could be made aware of, or if it was available at the time of the first petition, This is going to have a major impact going forward. And really the takeaway here is that you need to disclose the best prior art right away, and there's no more 2 bites at the apple. And I think the PTAB had done this to really curtail what they saw as a potential abuse of the system, where petitioners would strategically unveil the better and better prior art. If you get it instituted with your 5th best reference, you could go ahead and do that. If not, you could always go back and try with the 4th and the 3rd and so on. And an overloaded system saw that, an already overloaded system saw that as a potential abuse. So what they decided here was that if you could have been made aware of that art at the time of the first, you need to disclose that. Otherwise, you will not have the opportunity for a second petition or even potentially a rehearing of that. So again, bringing that back to what we talked about before, again, due diligence being a major challenge and having access to the most appropriate or the highest quality technical information is, and I think that will be the case going forward, especially as the PTAB kind of continues to expand. And we've seen crowdsourcing be a very effective tool for doing that, and we think it'll be helpful going forward. And so the last thing I wanted to talk about were some future crowdsourcing initiatives. I guess one being definitely in the future and one kind of being in the present, but very new. So we thought to include it here as well. So first of all, there's another application of crowdsourcing here, and that's in terms of idea generation and technical problem solving. And Patexia was actually fortunate enough to be awarded a new contract through the NASA Tournament Lab, where NASA and some other government organizations will be funneling some technical challenges to crowdsourcing platforms like Patexia and several others, even a few that are based here in Santa Monica, which we're pretty excited about. And this is, again, using the wisdom and the power of the crowd to come up with novel applications of existing technologies or to come up with unique problems that NASA is currently interested in. So it's a great opportunity for us to be working with them, to be introducing some of our problem solvers to these high-level challenges. It's something that we're certainly excited about starting, and it'll be over the next few years, and we're looking forward to getting going with that. And now in the future is going to be some work with the USPTO. We've been involved with some conversations. There was a couple crowdsourcing roundtables held by the USPTO last year. There was one in April, and then there was one in December in New York. And they were talking about building a type of crowdsourcing system to allow for third-party pre-issuance submissions of prior art, basically allowing examiners or giving examiners access, a crowd of some type, in order to kind of support their own examination and evaluation of prior art. And it was a good separation of tasks, essentially. It's allowing an examiner to evaluate prior art and determine novelty, while it was allowing a designed and a curated crowd to do what it did best in finding technical information. So it's an ongoing conversation. We're looking forward to seeing where that goes, and we'll certainly keep you guys posted about that. And so that basically wraps up this ins and outs of crowdsourcing webinar. I hope you guys enjoyed it and took something away from it. I certainly enjoyed talking this morning. So I'll remind you guys about our next webinar, which is going to be next month. It's Thursday, August 6th. It's going to be the same time, 10:30 a.m. Pacific time. Now, this talk is going to cover IP valuation in terms of understanding the financial value of, and it'll be given by who is the president of Foresight Valuation Group. So we're excited to have Efrat give a talk with us next month. And then going forward, we're going to keep this IP Matters webinar series going. Going to pick it back up in full force. And we're going to have one of these every first Thursday of the month about the same time. So we'll certainly keep you guys posted. We hope you can make the next one and future ones as well. And I wanted just to kind of leave you with some information and remind you that you can ask some questions by tweeting us at Patexia using the hashtag IP Matters. For anything else, you can contact me, Kyle Holger. My email is just kyle@Patexia. My phone number is there if you'd like to give me a call. And these slides are going to be available on SlideShare, and the video is going to be available on YouTube. We will email you guys a link to that once it's all ready and prepared so that you can go back to it for future reference. So I hope you guys enjoyed the talk today. I certainly enjoyed speaking with you here this morning, and I look forward to our next webinar.